contracted by CPS. Now, we are looking at a similar situation in several states. Sometimes it is difficult to show that there is a direct connection between the pediatrician or the medical services and the agency, but I have been able to find in Tennessee that Vanderbilt University receives $4.5 million directly from the Department of Children's Services. Now, of course, they will say those are services provided after children are in foster care, but still there is a financial connection. Let's take a look at this article. Since 2006, expert pediatricians working for Child Protective Services in Texas wielded decisive power in deciding which injuries were accidents and which could be signs of abuse. But beginning this month, parents who come under suspicion for physically harming their children will have the right to a second opinion and in-person examinations, not merely paper reviews. A new state law effective this month scales back the influence of doctors working for Forensic Assessment Center Network, which has provided consultation to the Department of Family and Protective Services since 2006. Network doctors received as much as 60% of their salaries from the Child Welfare Agency, consulting on abuse and neglect cases and providing expert testimony in court when children are taken from their homes into foster care. As of September 1st, parents accused of child abuse based on these forensic specialists review their case. The specialist review of their case will be able to obtain a second medical opinion, regardless of the ability to pay, and to present conflicting opinions to a judge in family court. Following high-profile exposés of medically fragile children wrongfully separated from blameless parents, critiques of the Forensic Assessment Center arrangement have become increasingly vocal in this state. Critics of the Forensic Assessment Center arrangement have been increasingly vocal in this state, taking issue with that they perceive as a child abuse specialist conflict of interest and lack of impartiality. This type of case, where the state controls the only expert, says Rep. Jean Wu, creating an inherent unfairness for parents fighting to keep custody of their children. If you are a hammer, everything looks like a nail, Wu said. If your job is to find child abuse, you're going to find child abuse, whether there's really abuse or there's not. The Department of Family and Protective Services declined to comment, and representatives of the Forensic Assessment Center Network failed to respond to reporters' inquiries. Retired family court judge Michael Schneider, now in private practice representing parents, said the new law could have spared two of his recent clients from a traumatic separation with their medically fragile infant. In early January, when 7-month-old Casey Lee arrived at Texas Children's Hospital in Houston with a broken femur, medical staff found several other fractures throughout her small body at various stages of healing. Snyder said after a pediatrician working for Protective Services called the fracture suspicious and alerted authorities, Casey's parents, Wendy Wu and Jean Wu, were barred from entering the baby's hospital room without supervision. When Casey was discharged after 2 weeks, she could not go home with Hay and Lee. Instead, she was moved to a neighbor's home while her parents fought to regain custody in family court. It took 4-month legal battle to convince a judge that Casey's injuries were not the result of abuse, but metabolic bone disease that left her body so fragile even a diaper change could cause fractures. That was established with a second medical opinion, and the court ruled that Casey could safely return to her parents. Snyder said those clients were among the lucky ones. He took the case pro bono and drew on his personal experience from sitting on the bench in family court. In defending Ho and Liu, he presented evidence from an orthopedic specialist who countered the state's expert in court. Other Texas parents, those without the ability to spend tens of thousands of dollars on independent expert witnesses, have long been at a disadvantage. He added, in large number of cases, Snyder said, the child abuse specialists just come up with a diagnosis and they stick to it no matter what. They don't budge. In addition, such influence, Senate Bill 1578, authorized by State Senate Louis Kolkhorst, requires the Child Welfare Department to refer the child for a second medical opinion from a specialist who was not involved in the original medical report of abuse or neglect anytime parents, social workers, or treating physicians make such a request. The new law was prompted by an NBC investigation that revealed several cases of children like Casey who were wrongfully removed from a safe home and needlessly placed into foster care on the sole recommendation of child abuse pediatricians. Examples include Mason Bright, who was 5 months old in 2018 when he fell from a lawn chair in Houston suburb while playing at home with his mother and 2-year-old sister. A child abuse pediatrician at Texas Children's Hospital found 2 skull fractures and determined that they couldn't have come from the fall, one news outlet reported. Weeks later, as family relaxed together after dinner one evening, a social worker arrived to take both children to the foster home. Snyder, who presided over the case before retiring from the bench, told the Imprint he is still haunted by the audio recording of that moment. The sound of the calm little girl trying to pacify her anguished mother nearly brought him to tears in the courtroom, he said. She was trying to call Mommy, it's okay, Snyder recounted, not realizing someone's about to essentially kidnap you. Snyder said that he ordered Melissa and Dylan Bright's children returned back to them and fined the department $127,000 to cover the family's legal cost. Child abuse pediatrics is a relatively new subspecialty, first recognized by the American Board of Pediatrics in 2006. It remains an exceptionally rare field of practice. There are roughly 350 board-certified pediatricians and approximately 300 practicing nationwide, said Susan Haney, chair of the American Academy of Pediatrics Council on Child Abuse and Neglect. To become board-certified in this area, doctors complete a 3-year fellowship in addition to the standard pediatric residency, training that includes instruction on child welfare investigations and how to navigate court hearings. Recent figures show that physicians with Forensic Assessment Network Center in Texas have provided consultation for 31,000 children suspected to be victims of abuse and neglect. The cases are fraught for two central reasons. The children are being examined tend to be too young to explain how they've gotten hurt, and the types of underlying illnesses can cause injuries that appear to be abuse are often rare disorders, conditions that emergency room physicians and family doctors may be unfamiliar with. But Haney of the American Academy of Pediatrics says child abuse pediatricians are specially trained to recognize symptoms that could be misdiagnosed as abuse, and more often than not, they identify the underlying conditions. She said requiring a second opinion is rather redundant, placing a greater burden on the relatively few, already overloaded child abuse pediatricians there are. None of us operate in a vacuum. I'm not making that diagnosis just by myself, Haney said. I may be the person whose name is out there, but I'm talking with our other neurosurgeons and radiologists, and if you know any of them says, wait a minute, that it's a discussion, we sit down and we look at things. Haney is also critical of another feature of the new Texas law, requiring an in-person examination, not just a review of the medical record in child abuse reviews. Haney said there are not enough specialists available to perform an examination for every child they ask to consult on, and that they are not always necessary. If a CT scan shows something there, it's not going to change whether I actually see the child in person or not, Haney said. Nationwide, allegations of abuse and neglect are made by medical professionals are 40% more likely to result in child welfare agencies determining abuse or neglect occurred than reports made by teachers, neighbors, and other community members, according to the Marshall Project analysis of national data. and the opinions of child abuse pediatricians on contact carry significant weight with judges, particularly because most parents lack the resources to counter their testimony, Wu said. What's more, in family court, the burden of proof is lower than in criminal cases. To separate a child from their parent, child welfare officials don't have to prove their allegations beyond a reasonable doubt, just that the abuse likely occurred. The courts are sort of put in this untenable position where they don't really have a choice, Wu said, and it's just better to err on the side of caution than not. Correction, the American Board of Pediatrics was incorrectly referred to as the American Academy of Pediatrics in an earlier version of this story.